So, after Prince Harry's loss in his judicial review application, a lot of you have asked in the comments, can he appeal this and does he have any chance? The answers are he can try to appeal it, but he has no chance whatsoever. So this is a good opportunity for me to explain about appeals generally. The first thing to understand is that in both civil and criminal proceedings in England and Wales, generally you have no automatic right of appeal. There are, however, some exceptions to that. One exception is you have an automatic right of appeal from the magistrates' court to the Crown Court. So whether you're convicted in the magistrates' court or you are sentenced in the magistrates' court and you just don't like that, you have an automatic right to go to the Crown Court. In the Crown Court, it's what we call a de novo hearing, which is very unusual. De novo means from new. In other words, they start from scratch. They disregard everything that happened in the magistrates' court, and it's just a rehearing, and that's in front of a Crown Court judge and two magistrates. And you can appeal either conviction and obviously subsequent sentence, or just the sentence. The risk, of course, being a de novo appeal is, especially when you're appealing sentence, it could go up. So that's something you have to bear in mind. There are also automatic rights of appeal. If you are committed to prison for contempt, you have an automatic right of appeal. And also if you're denied a writ of habeas corpus. And there are a few other technical ones. But generally speaking, before you can appeal, you must first obtain leave to appeal, sometimes called permission to appeal. And the test for that is that you have to show that there's a realistic prospect of success on an appeal, or that there's some other compelling reason to allow you to appeal. So who do you seek permission from? The first person you seek permission from is the judge that's just found against you. That's quite often done just orally at the end of the hearing, especially if the judge announces their decision there and then. And you say, I'd like permission to appeal, please. Now, obviously, the judge is going to think that they've probably got it right. So it can be quite hard to get permission or leave to appeal from the actual trial judge. Sometimes, though, they will do it. Say, for instance, you've had a technical legal argument about an interpretation of a particular piece of law, and a judge finds one way. They might say, OK, I accept that maybe the appeal court might come to a different decision. There's one really lovely judge where I will stand up at the end after a hearing if I lose, which is, usual result. And it's like, oh, I'd like permission to appeal. And he'll say, oh, presumably that's on the ground that I'm a senile old duffer who doesn't know what he's doing and shouldn't be let loose in a courtroom. And I will say, well, I'll be phrasing it slightly differently. Although I once did actually appear in an appeal court and said, may it please the court, this is an appeal from a decision of Judge X. And they just went, OK, stop there, and just turned to my opponent and said, any reason why we shouldn't allow this appeal? But yeah, you've got to show grounds. Now, like I say, the good thing about when you don't have to show grounds, like in the magistrates' court ones, in my baby barristering days, even though you've got an automatic right, on the form it has a space for grounds of appeal. And I always used to write, didn't like result. You're supposed to put things like, the conviction was against the weight of the evidence. OK, but say you apply to the trial judge and they say, no, I'm not going to give you permission to appeal. Well, where do you try next? You try with the appeal court. So you go to the appeal court and you say, we would like permission to appeal, please. And you have to put in grounds of appeal. You have to explain, this is what we say the judge got wrong. And this is why we say the previous decision was wrong. You can't just sort of say we'd like to appeal. You have to set out and you have to sort of argue and say, look, there's every chance we might succeed succeed on this. It's only if you get permission to appeal that you are then allowed to progress to the full appeal. In criminal cases, an appeal has to be supported by an advice from counsel. So, somebody gets convicted in the Crown Court, we go to the Court of Appeal. We have to put in not just the grounds of appeal, we actually have to get counsel's opinion, saying on why we think, this is, has a punt, which I also puts quite a lot of pressure on counsel. Because what if it's your client and you think, actually, we're doomed, we haven't got an appeal, and you sort of, you bang in an advice and say, actually, this was probably a very, very safe conviction. Because we cannot mislead the court. We cannot put forward an argument that we can run arguments that are weak and terrible and rubbish, but we can't put in arguments that amount to abuse of processes. And that is always a fine line. And to be honest, if you don't get counsel's opinion in your favour, you're going to get knocked back just at the leave or permission stage when it comes to criminal appeals. I mean, sometimes people will seek separate opinions, like I didn't like trial counsel. And there are specialist appellate counsel, because it's a very different skill set. But what are the sort of grounds that you can appeal on? Generally speaking, it's got to be that the judge got the law wrong. It's very, very hard to appeal a finding of fact, especially when you're saying the judge shouldn't have believed this witness or something like that, because the appeal court always goes, the judge was there, the judge heard everything, we're not going to overrule that. I mean, you can try and argue and say, this conviction was against all the weight of the evidence, even the uncontested evidence or what evidence came out, have a look at this. But the test is, did the court come to a conclusion that no reasonable court could have come to? Or did the jury come to a decision that no reasonable, properly directed jury could come to? And that's a very high standard. The mere fact the appeal court goes, you know what, we would have come to a different conclusion, they can't substitute their own decision. But what can an appeal court do? They can reject the appeal and just say, no, sorry, the appeal fails, so you're back where the original decision stands. They can actually say, no, as a matter of law, we find it should have been this decision, and that's where they can impose their own conclusion on it. Or they can say, right, the judge got the law wrong, but we're not going to argue about the facts of this. We remit back to the first instance court for a fresh hearing, but bearing in mind what we've just said about the law. Generally speaking, you only get one go at an appeal. You can try for a second appeal, but the test is even harder because it's all the reasonable prospect of success, some other compelling reason, and generally it's got to be in the interests of justice to allow. And usually with a second appeal, you've got to show something like, we now have some fresh evidence or some fresh material that wasn't available at trial, and it wasn't reasonable to expect us to have it at trial. It's either only just come to light, or even with all our due diligence, we couldn't find it. So to bring us back to Prince Harry and justify this, what's happened? Well, he's lost a judicial review. The court has come to the conclusion and said, we find that the decision that was made by RAVEC, the Home Office Committee, was within a range of reasonable responses. Because like I say, a judicial review, it's the same test. It's not just we'd have come to a different decision. It's you can only appeal it. You can only succeed on judicial review if you can show the decision was so perverse, no reasonable decision maker could have made it. In this instance, the court said, no, we find it was a decision that was in a range of reasonable responses, and we're not going to interfere with it. They explained, the court does a really good judgment, explains everything, gets the law right as far as I can tell. So it's going to be really, really difficult. So although Prince Harry will undoubtedly bang in an application for permission to appeal, my prediction is, which I will come back to if it succeeds, and say he will get knocked back at the permission stage. And I'll do a quick edit here and say, my prediction is that he'll succeed on the permission stage, but he'll get knocked back on the actual appeal. I mean, to cover myself, I suppose I should just do one saying, yes, it's clear that Harry will succeed on this. I mean, he won't. He definitely won't. He will get knocked back at the permission stage. So there you go. Hope that answers all your questions in the comments. I'm going to stop talking now because while I've been talking, the tide has come in. I'm now sort of like getting to be ankle deep in water. But where am I? I'm at a place called Low Beach near Fiocc, or Restaurant Creek. I don't know how to pronounce it. But that's the River Fal. If you just look down there, the bit on the right, round the corner, is Falmouth. I actually came over here because I wanted to film on the King Harry ferry, because I thought it'd be, sort of vaguely appropriate, King Harry, Prince Harry, etc., etc. But there you go. I'm now going to stop rambling now because, like I say, I'm getting very, very wet. I'm just going to pan down just so you can see where my feet are. I hope this works.